you have a, sorry, I got something that popped up. You have a standard on review of, manifest abuse of discretion, even higher than just a standard abuse of discretion. So Your Honor does have the authority to look at everything that went on here and say that this would be unjust to let this go forward. And we've already explained what the circumstances were, just as how all that applies to excusable neglected. It as much, if not more, applies to proper cause. You didn't have service on an employee of either of the defendants. It was served at a location that was run and operated by another non-party. It was misplaced by a non-employee of the defendants. Cole Family Entertainment, in all honesty, never even didn't own or operate the location where the incident supposedly occurred, and so isn't ever going to be able to even be liable, yet now has a $425,000 plus judgment against them. None of this was done intentionally. It wasn't done with gross negligence. It is something where you have the plaintiff who was somehow, without noting, never actually communicating with the defendants themselves, ended up in contact with their insurance company pre-suit and was conversing with them pre-suit, with the insurance company pre-suit. But then that, I guess, breaks down. They file a suit, don't tell the insurance company, which might have helped save all of this. And then don't contact, and then after default judgment is entered, go and contact the insurance company again to try and collect. And that it's only then that the defendants actually learn that the lawsuit was even filed. If this was a situation that could have been avoided if everything was done correctly, sure, but because of the circumstances, both of COVID, both because of how communications were made and who they were made to, because of how service was made and who it was made to, that Cole Family Entertainment and Extreme Air never actually learned of this lawsuit until after the judgment was entered. It's a situation that is highly questionable, especially when you've got a $425,000 judgment for, at least in the complaint, what seems to be $53,000 in meds. Obviously, you don't know what happened at the damages hearing at the trial. Understand that there was one, but that there's no transcript of it. If medical records were entered and submitted, don't know if they were ever properly authenticated. If the plaintiff was claiming future injury, we don't know if they brought in medical testimony to actually establish that, which is what is required even in default judgment hearings. Leaving the $425,000 judgment in place against these two defendants under these circumstances would be unjust, especially considering that Georgia wants these things decided on the merits. Even if the court doesn't consider to reopen under 21EV004391, it can still set aside the judgment under 21EV0060 if this was a final judgment. If it becomes a final judgment, now the case civil disposition form entered, we're still within the same term of court. And so under the term of court rule, the court has discretion to reconsider, vacate, modify a judgment that it entered during that term. Additionally, you've got under 21EV0060D, you can set aside the judgment for lack of jurisdiction. That would be the personal jurisdiction that we've talked about based on lack of service. Obviously, you have Sky Zone LLC issue, and with having never been served, but then for the other two defendants, what we've discussed already about whether or not that is proper service, which we do not believe it is under 911-4E. You've also got the issue of 911-60D setting aside for non-amendable defect. There's potentially two here. One is the issue that I kind of just discussed, which is establishing damages in the proper way. They still have to do that in the default judgment context. And with the amount of damages that were awarded, $425,000 compared to the 53 in potential meds or potential special damages, there is a question as to what all that is for and what it's related to, and if it actually has been appropriately supported as is required under the law, such as any future type of pain, suffering, or injury, ongoing issues that might have been alleged, and whether or not even the specials had been properly.
Well, of course, I know I've heard you talking about this, but of course the damages were properly supported, Mr. Khan. I was there. That's why I entered the judgment. I heard all of it. So I appreciate what you're saying that you don't know, but I wouldn't have entered judgment on things that weren't properly before the court. So you can continue on that, but that's not helping you at all.
Understood, Your Honor.
You've gone on quite a while about what you don't know about what happened at the trial.
Yes, Your Honor.
Okay. Yes. Anything else?
The other non-amendable defect would be the apportionment of damages aspect of it. The judgment doesn't apportion damages, even though it says as to defendants generally, assuming that the award, and I guess it is an assumption that maybe I shouldn't make, and Your Honor can tell me if I'm wrong on this, please. But as far as the award, if it's to compensate the plaintiff fully, then it doesn't apportion the potential damages with Sky Zone LLC, which is another defendant in this case. And, I guess it doesn't, unclear whether or not they were supposed to be, if they're supposed to be included in the final judgment, or if they're not, and if they're not, if there was that apportionment. But regardless, amongst all three of them, or the two that are in, or the co-family and extreme error, it's not apportioned between them either.
Okay. All right. Anything else?
No, Your Honor, I appreciate the time and certainly happy to answer any of the questions that you might have, but otherwise, based on those grounds, we respectfully request that the court open, default, or set aside the judgment. Okay,
thank you. Mr. Michaelman?
Thank you, Your Honor, and thanks for bearing with me. I think I've got my technical difficulties figured out here.
Looks like it.
So, and again, we appreciate the opportunity to come and tell our side of this to the court. And really, I think that our position here is that the judgment is water under the bridge, and they're coming in here after the fact and trying to undo it. And I don't think that any of the issues that we heard Mr. Khan raise are issues that would allow the court or should allow the court to alter the judgment, with the exception that perhaps the court should make it clear that only defendants that are served with a lawsuit would actually be parties to the lawsuit, and they would be the only ones that judgment would be enforceable against. But I think, really the main issues that Mr. Khan raises are, number one, there's sort of just a generic COVID excuse without really there being a reason why that was anything other than just basic neglect as opposed to excusable neglect. And then with regards to the service issue, Mr. Cole doesn't dispute, and it's clear from the process server's affidavit that the process server went to the address that Mr. Cole designated where he was able to be served with process of the registered agent of his corporation. The process server went to that address. He actually spoke to Mr. Cole, who designated an agent that was there at the location to accept the service on his behalf, which was who the process server served. It's laid out real clearly from how I read the affidavit. So to me, to then turn around and say, oh, I didn't know I was being served, or I didn't see the papers. I mean, he literally was called by the process server on the day that it occurred, knowing that he was there and going to serve the papers on the agent. So to then say after the fact, oh, I never got the lawsuit, or I didn't get the papers, or this was all a COVID issue, or the person that this isn't a employee of the corporation, or they've come up with a whole laundry list of arguments, but at the end of the day, that's an individual that Mr. Cole designated at the time, and he had personal knowledge that he was being served with that lawsuit on that date. So I don't think that is anything other than ordinary neglect. I certainly don't think it's excusable neglect. And then I think I guess maybe there's some dispute with regards to the term of the court. I had thought that the term of the court was over relative to when the judgment was entered. And nonetheless, I mean, I consider that civil disposition form issue sort of a technicality after the fact. I don't think it's a reason that would or should prevent this judgment from going forward. Nonetheless, we filed the disposition form, not because we feel like it was a fatal error in what was done, but just because it sort of cures that, that argument that the defendant is making. So, I think that's the gist of our position. There is a corporate defendant that wasn't served, but I don't believe they're a necessary party. I don't know that they would ultimately ever have any, an apportionment responsibility for this, what happened at this franchise location anyway. Let's see, and I think those are really that's really the gist of it, Your Honor. Is I think that had things not been done the way that the court wanted them to have been done, I don't think that this court would have granted the default. I don't think they would have held the damages hearing and gone through, with things the way that it had done. Now that it comes time for the judgment to be collected either from the defendants or the insurance company, now they want to go back and undo what was done. Mr. Cole knew he was being served with a lawsuit. He didn't do anything to, protect himself from, despite the fact that he knew that was done, and the consequences for his decision are where we are now. And again, I haven't heard anything from the defense that makes that neglect excusable or should allow anything that's been done to be undone. And thank you.
Anything else, Mr. Khan?
Just, Your Honor, just to quickly, I don't want to rehash what I've already argued.
No, you don't have to do that. I was just saying if you had anything that Mr. Michaelman brought up that was new.
Yeah, I understand, Your Honor. Just that we believe that the circumstances are inexcusable neglect. We think that both, just as the misplacement of the papers, there's case law, which we cited in our brief, where that has been found excusable neglect, proper cause. And when you couple that with what this world has been going through over the last 2 years, we think that provides even more justification than what you would have found in those cases where it's been found before. We think the civil disposition form is a requirement. It says shall in the statute. And, ultimately, likewise, 911-4E has specific requirements about who is allowed to be served. Mr. Ogle does not fall within the people who are allowed to be served. So that's all we have, Your Honor.
Okay, Mr. Michael, I'll give you the last word. Anything else?
I guess the only other thing I would add, Judge, is that I do think I would certainly agree with Your Honor's bringing up the fact that if costs haven't been paid, then the motion might not even be procedurally, ripe to be heard today. But I also think that, other than that, the other issues that I raised as far as the timeliness and the time now of which they're coming to challenge this motion, I think are also relevant and should be considered as a reason why the motion to open the default should be denied.
Okay. Well, I appreciate y'all's arguments. I will take this under advisement and we will get you out an order on this post haste.
Okay. Thank you, Judge.
Thank you,
All
Your
right.
Honor.
Okay. Appreciate it. Y'all take care. And you know what? Before I let y'all go real quick, we go off the record for a moment real quick. And then Ms. Walker Bailey, you're on until 11:30. How about that? Okay. I assume y'all are going to continue to talk while we are reviewing this request to set aside. Just from a practical standpoint, I do know, and I don't know what position, and maybe nobody does, but maybe y'all have already talked about it, on what position the insurance company is going to take with respect to whether this is going to be covered loss when they weren't put on notice by their insured. And so I guess y'all could continue to talk, and if that, before I get an order out, that bears fruit, then y'all let us know, okay?
All right. We will, Your Honor. Thank you.
Yes, Your Honor, absolutely. Thank you.
I'm sure y'all have thought about that, I know, but I tend to, sometimes I've had folks come in and say, maybe if you wait a minute, we need to have this discussion because the insurance company at this point may be a little more, maybe a little more flexible than if I say that, and if I deny the motion and they just say, no, we ain't covering it. And who knows if there's enough assets to cover it by the company. I don't know. Maybe y'all already know all that.
We've done some investigation into that, Your Honor.
Okay, so y'all are already aware of all that. Okay, got it.
Yes, sir.
Okay, all right. Well, then I will let
All right.
y'all go, and we'll get y'all out an order.